Justice Sotomayor?
No, she's Justice Sotomayor. She just finished.
Justice Kagan?
General
And
Sa-
they're friends?
I want to take you back to Justice Thomas's question about non-delegation. And if I understood your answer correctly, it was really similar to the answer that you started off with when you talked with Justice Thomas about the major questions doctrine, which is sort of everything's different because the president has independent constitutional powers in this area. And so that if one does not think that with respect to tariffs, if one thinks that a tariff is a taxing power, is a regulation of foreign commerce that is really delegated by the Constitution to Congress, that argument does not sound so well. And in fact, when you look at J.W. Hampton, which gives rise to the non-delegation test that we usually use, J.W. Hampton is a tariffs case. And the court did not say, oh, we need some special new principle here, some stricter rule because we're dealing with tariffs in which presidents are directly concerned as a matter of foreign relations. It enunciated the test we use for all non-delegations. So how does that fit with your theory?
8 years later, in Curtis Wright, the court held the non-delegation doctrine for domestic affairs does not apply with the same force as it does in foreign affairs.
But not with respect to tariffs, not with respect to quintessential taxing powers, which are given by the Constitution to Congress.
I think justices of this court have recognized in their opinions that one of the reasons that the non-delegation doctrine, that intelligible principle test hasn't packed as much punch as Justice Kavanaugh said in one of his opinions as it might otherwise have done is it did arise in the foreign affairs context because there the court has historically been very, very comfortable with very broad delegations. Chicago and Southern Airlines, another case from the 1930s, shortly after J.W. Hampton talked about being very large delegations of the foreign commerce power being very effective. And of course, this goes back to the very dawn of the Republic in 1790, for example. Congress conferred on President Washington basically the entire Indian commerce power. It said, go, get licenses, right, to do commerce with the Indians, and they'll be subject to whatever rules and regulations President Washington can make. So I do think there is a profound consistency between the announcement of the intelligible principle test in J.W. Hampton and then the subsequent recognition by this court in Curtis Wright that the non-delegation doctrine doesn't apply to the same force in this context.
In consumers research just last year, we had a tax before us, and the question was this a delegation issue? It was, of course, a much smaller tax, which dealt with many fewer taxpayers. Notwithstanding that, we said if there's no ceiling on this tax, we sort of assumed that if there were no ceiling on this tax, it would raise a delegation problem. And most of the opinion was given over to showing that there, in fact, was a ceiling on the tax, not a quantitative one, but a qualitative one. But how does your argument fit with the idea that a tax with no ceiling, a tax that can be anything, that here the president wants, there an agency wants, would raise a pretty deep delegation problem?
First of all, I can't say enough, it is a regulatory tariff, not a tax. And that, I think, ties to my response to that, which is that this is a totally different context. This is IEPA, a statute that Congress carefully crafted to grant the president admittedly broad powers to address foreign arising emergencies. It's outward-facing to foreign affairs, where there's the broadest level of deference to the political branches. This court has recognized in many cases. And it imposed not a floor or limit on the amount of a tariff that could be imposed very naturally because, for example, as this court said in Loving, quoting Alexander Hamilton in the Federalist number 23, it's impossible to foresee either what exigencies may arise or what tools may be needed to address those exigencies, the means that may be required to address those exigencies. Instead, Congress grant very broad powers, but they're confined to a particular domain. This domain is any property in which any foreign government or any national thereof has any interest. So the sort of discipline, if one were to apply, we say you shouldn't, but if you were to apply the non-delegation doctrine, the domestic-facing non-delegation doctrine in this context, there's a significant limitation there.
Yeah,
where
so
you have
my last question really does have to do with that point, which is how or whether this is confined. Because if you look at Title 19, which is loaded with tariffs and duties of various kinds, all of them have real constraints on them. They are, you can't go over X%, or it can't last more than 1 year. And of course, the way you interpret this statute, it has none of those constraints. And the question arises why it is that any president ever would look to the tariffs in Title 19 if sub silentio, if you will, this statute gives the president the opportunity to blow past those limits.
This statute has its own constraints. They are constraints that are appropriate for the context, which is internationally arising emergencies. They are carefully crafted by Congress to address that, and they are admittedly different. They're in Section 1701. The president has to make a formal declaration of a national emergency, which subjects him to particularly intensive oversight by Congress, natural lapsing, repeated review, reports, and so forth. It says you have to consult with Congress to the maximum extent
I mean, you
possible.
yourself think that the declaration of emergency is unreviewable. And even if it's not unreviewable, it's of course the kind of determination that this court would grant considerable deference to the president on. So that doesn't seem like much of a constraint.
But it is.
And in fact, we've had cases recently which deals with the president's emergency powers, and it turns out we're in emergencies everything all the time about like half the world.
Well, this particular emergency is particularly existential, as Executive Order 14257 says, and of course, no one disputes the existential nature of the fentanyl crisis, which, we had an agreement last week to create progress on, which illustrates the effectiveness of the tariffs tool here. But the point I would make in response to that is, those are, even if there's limited judicial review, which is very natural in the foreign affairs context, this court has always granted the president the presumption that he's acting in good faith. There are real hurdles there, very significant. It's got to be an unusual, extraordinary threat that arises in whole or substantial part outside the United States, so it's entirely foreign-facing into the national security, economy, or foreign policy of the United States. So there are those. Then there's 1701B, which talks about how it can be used for this and for no other purpose. Then there are limitations in Section 1702B. Then there is the limitations that I referred to earlier about what he can actually do. He can do a heck of a lot, but only when he's dealing with property in which foreigners have an interest, and that's a pretty narrow domain. That's quite a silo, so to speak. And then, of course, overarching it all, there's congressional oversight, and you may say congressional oversight may not have much bite, but Congress didn't think so. Congress crafted this compromise. It balanced the never-ending tension. When it drafted AEPA, it had its eyes open, as the dissent below says, its eyes open looking at the problem of sweeping emergency powers for an executive who may use them in a way that's excessive versus the need to address unforeseeable emergencies.
Thank you, General.
Justice Gorsuch.